U.S. District Judge Aileen Cannon is facing calls to step down after she ruled that if the case against Donald Trump were allowed to proceed, jurors would have to be allowed to see this country's national secrets. It's either that or dismiss the case entirely. In her most recent filing on Monday, Cannon wanted to task jurors with figuring out if the former president could rightfully consider the documents as his own personal property. And again, in order to do that, jurors would have to see these documents. Her filing says, in prosecution of a former president for allegedly retaining documents, a jury is permitted to examine a record retained by a former president in his or her personal possession at the end of his or her presidency and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is personal or presidential using the definition set forth in the Presidential Records Act. Now, she had written this during a hearing that involved asking federal prosecutors and Trump's lawyers for jury instructions for the upcoming trial. Now, the problem here is, one, the jury instructions would be written in a way, thanks to her ruling, thanks to her filing, to where either they would have to dismiss the case against Donald Trump because, well, you don't have a case if you're not going to allow someone to actually make this decision of whether or not you think it's personal or government documents because you're not allowing anyone to see them, or you have to allow the jury to see these potentially sensitive documents. So it puts him Jack Smith in a pretty bad position here because he would either have to worry about, do we protect classified records, or do we allow Donald Trump to go and to gain a lot of power? Now, that second option, again, would have jurors agree that a president has sole authority under the Presidential Records Act to categorize records as personal or presidential during his or her presidency. And also, furthermore, says that neither a court nor a jury is permitted to make a review such a categorization decision. So you let Donald Trump go, you give him and any other president in the future a massive amount of power to decide what documents they can take from the White House when they're done. They could take everything. They could take whatever nuclear secrets, whatever defense secrets, whatever war plans, whatever they want. And no one else could stop them because no one else would have access to those files. That's it. They're my personal files now. I'm just going to take them. And I don't have to tell you what I'm taking. I'll just take everything. That's insane. This is absolutely insane, this ruling. Lawyer Judge Conway took to threads and immediately called for Cannon's removal, saying, I've seen enough. Not only should Aileen Cannon not be sitting on this case, but she should not be sitting on the federal bench at all. This is utterly nuts. Conway added that in the decades that I've been a lawyer, this is the most bizarre order I've ever seen issued by a federal judge. What makes it all the more amazing is that the second and third most bizarre orders I've ever seen in federal court were also issued by Judge Cannon in this case. National security lawyer Brad Moses writes, the second scenario is legally insane. The former Obama administration ethics czar, Norm Eisen, wrote that the order was, quote, clumsy and amateurish, and ignored the different body of law that governs classified documents, including Executive Order 13526. That was during the Obama administration that set up this classification system. Now, Andrew Weissman wrote, this is a kind of legal inanity that could lead Jack Smith to seek to mandamus Judge Cannon, i.e., to get to the 11th Circuit Court of Appeals to hear this and reverse her for the third time, which could also be the proverbial 3 strikes and you're out. So now that's interesting, right? And he's not the only one that mentions mandamus. In fact, attorney Robert Kellner writes, while it's unlikely, it seems to me Cannon's latest order is sufficiently bonkers that Jack Smith might at least entertain the thought of a mandamus motion. I doubt he'll do it, but he's got to be thinking about it. Now, what is this writ of mandamus? Well, it's an order from a court to an inferior government official, in this case from the 11th Circuit to Judge Cannon, ordering that government official to properly fulfill their official duties or correct an abuse of discretion. And it's not the first time they mention that the 11th Circuit has had to reverse one of Cannon's decisions because of how insane it is. And so the thing is, right? The thing is, we've got already two pretty terrible choices. None of them are good, right? And then you have this, which is, seems like it's the best option, right? Well, the problem with that is that it gives Donald Trump a delay that he is seeking. This appeal would take time and would mean more delays in a trial that's already at least 3 months behind, thanks to Cannon's machinations. Slow walking the trial, and now making this decision. So, I mean, we've got a really bad, situation here. It's lose-lose for Smith and lose-lose for democracy as well. Depending on what documents Donald Trump has, the government might not be willing to allow a jury to see them because they are national secrets. At the same time, well, we can't just let Donald Trump go and say that he has this massive authority to hoard whatever classified documents he wants. But also, we don't want to give Donald Trump another delay to where he could become president and then tell the DOJ to stop investigating him. So this is where we're at with the documents case, thanks to Judge Cannon being in charge. That is why she's 100% in the tank for Donald Trump and should be removed and replaced with someone who actually wants this trial to proceed and to proceed fairly. Because with Judge Cannon, we do not have that.